It's Alex Scott here from the Union Office. If you are struggling to hear me, we are having some challenges with the internet connection at the Union Office, so please go to the chat and indicate if there are problems in relation to the audio sound. In terms of this process, we will be providing a copy of the presentation after today's meeting, and we'll also do a follow-up email to people who've registered, but also people online for further questions if you have them in relation to this, to where we're at with a variety of issues in the public service. We will try and keep today's session to exactly half an hour. I know we've had a bit of problems keeping that time frame in the past, and I also want to apologise for the late cancellation of the last one of these meetings, but it has been a period of quite quick change in relation to the processes within the public service. So we wanted to give you accurate information as to where we'd finally got to in terms of this process. So broadly this afternoon, we want to talk about public sector wages, and then talk about the public amendments to the Public Service Act, the Queensland state budget, or the kind of financial position of the state government in relation to their savings and debt plan, and also briefly touch on return to office for particularly workers within the Brisbane CBD, although we have a number of members across the state dialed in today. So in terms of public service wages, this presentation is designed for members who are covered by the core EB, and that agreement has been in place, was certified earlier this year. As we've been in the situation for the last couple of years, public servants who are under the core EB, and also subsequently the education agreement and also the child safety agreement. All those agreements come from the core EB originally from a few years ago, and they have all had a situation where their award wages are now higher than the expired rates that existed for the 2015 core EB. As a result of that, there are two ways that your wages can be improved. One through changes to the award when they're higher, and the other process through collective bargaining. In terms of your current wages, Together was able to get an increase to award wages of an increase of 1.75% through the state wage case this year, which reflected the national wage case. And that now has applied from the 1st of September, and we were able to get that applying to the Public Service Award. So the awards will increase by 1.75 from the 1st of September. Indications are that the actual change of when people will start receiving that pay increase will be in the pay of the 7th of October or thereabouts. You should see back pay coming through. That won't apply to some of the other public sector agreements where wages have been higher than the core and are higher than the award, but for the core related groups, it will be that increase. And that also, though, doesn't change the process that's been occurring in relation to the award the EB negotiations that occurred late last year, which was that the issue of the relativity between the award versus the EB was what was kind of the underpinning of the failure to come to an agreement between workers and the government in 2018 and 2019 on the issue of whether or not future pay increases would be based on what people are getting paid, or whether it would be based on the previously expired EB rates, which were significantly less than the award rate. So those negotiations are continuing with government, and we are hopeful of trying to get an outcome that results in the government agreeing to wage increases above the award and for the collective bargaining process. If we fail to come to a negotiated outcome with the employer, we have the ability under the collective agreement that was certified earlier this year to have the Industrial Relations Commission seek to arbitrate what is the issue in relation to the relativity between the award rates and actual rates of pay and expired rates under the previous collective agreement. So we put back to government that we want to try and maintain with the 1.75 increase has meant we've caught up a range of the other collective agreements that were above the award, and so particularly for AO2s and some of the lower level groups, the core is now past transport. In terms of wage rates, they're still a little bit behind in terms of at the AO8 level. But in terms of what that's because of the wage freeze that occurred for public servants who are not on the award but on collective agreements. They're not getting a pay increase this year, but they're getting 2 pay increases in the following financial year to give them catch up. So we've put back to government that we want to, as an option other than arbitration, is to see whether we can try and get those 2.5% matched into the future years, so we can lock in the catch up we've had through the 1.75. We don't know whether the government will accept that, but we're hopeful over the near period we'll be able to have some sort of position where we can negotiate an outcome. But if we fail to get a negotiated outcome in terms of locking in wage increases above the award through the enterprise bargaining process, there'll be an arbitration of the award rates later this year in terms of the Industrial Relations Commission. Our ability to win that case has been reduced a bit by the fact that we are now getting in parts of the core now paid higher than parts of the Transport Department, which was one of the key kind of benchmarks that we were saying we needed to catch up to. But we were still behind where we're at with Queensland Health, but they have different award conditions and different hours of work and such like. So that is still something that is part of the ongoing discussions and negotiations with government. We haven't had a response yet in relation to the ability to come up with a negotiated outcome, and we would hope to have that some sort of position before the end of the month or early October, because otherwise we'll get into the caretaker period and all those negotiations will effectively go into a holding pattern during the caretaker period, and we wouldn't then be able to get any substantial movement from government to realistically mid-November. So we want to keep that pressure on them to try and come up with some outcome, but at this point in time we haven't got further in terms of that. In terms of the second issue, which is in relation to the legislative review process, there has been substantial changes during the last couple of weeks, which is why we've delayed the regular briefing for members about exactly where we've got to in terms of the Public Service Act. As previously discussed, the legislative reform process has been ongoing for a number of years now. It started originally with the Together Union campaigning for a review, which then was undertaken by Peter Bridgman in relation to the Public Service Act. We then, that kind of stalled for about a year, but then as part of the negotiations for the outcome of the collective agreement process, we were able to have the Joint Advisory Committee created to look at the implementation of the review of the Public Service Act. And that committee's been operating since January, when we had the kind of breakthrough about the Core B negotiations in December. And that's resulted in some legislative amendments and also some consequential changes to the directives. In terms of that, given the timeframes around the elections this year with a 4-year term, we had to prioritise what was achievable between January and September in terms of a legislative program. And so there was an agreement at the Joint Advisory Committee to do 2 tranches of work. One tranche being this year, we were able to prioritise a number of the key issues in relation to employment conditions for workers, but then there'll be a second tranche of work after the state election in 2021, 2022, which will consider the kind of broader recommendations from the Bridgman Review in terms of a more fundamental rewrite of the legislation. But in terms of this process, we were trying to get as much done as possible prior to the election, which was a reasonably tight time frame, to try and then get some commitments about having that legislation, those amendments considered, and we were able to get that legislation considered and amended during the final sitting week of Parliament before the election. But there also is a series of commitments that we're still working through in terms of what stage 2 will look like. But clearly stage 2 will also be dependent on the government of the day, depending on the outcome of the election as to which side of politics is in charge, will determine potentially some of their policies in relation to stage 2 about what the nature of the legislation looks like, and what that process. So in terms of legislative amendments, when we last briefed you, the government had tabled their amendments and also started a process of consequential directive changes. And we were then working with members and delegates across the state to try and not only see the legislation passed, but also seek to try and improve the stage one legislation while still having a longer term view about what stage two will look like. We were working with members through the committee process to try and put pressure on the politicians prior to the state election to maximise the benefits in terms of improvement to members' conditions. And so what that looked like was a great effort from members across the state to put in submissions and sign the petition in relation to furthering the fundamental issue about how much detail was in the directives and how much was in the amendments. And so today I just want to kind of focus more on the changes we were able to get through, negotiate with government in relation to the process. So the committee itself made a limited number of recommendations in relation to the Public Service Act, but we were still able to talk to Cabinet and to the Premier's office in relation to the broader Public Service Act and what we really were trying to see achieve in terms of security of employment, security of income, and greater rights at work. So in the initial stages, the initial legislative amendments did go a long way in terms of achieving what we were seeking to do in terms of improving particularly the rights of temporary and casual workers to get better outcomes in relation to the conversion process, but it didn't go far enough from our perspective. And in conjunction with delegates and members, what we were seeking to do is make amendments, and a number of amendments were made on the day that the legislation was tabled in Parliament to adopt a number of the positions that Together and other unions have been advocating in relation to making sure that the government's rhetoric around employment security and certainty of employment was matched by the reality of the Public Service Act amendments. So one of those was in relation to the previous, the initial amendments sought to bring in some criteria about when temporary employment should or shouldn't be used. That criteria was linked to the previous directives around temporary employment and in relation to the temporary conversion process. And we were concerned about that the potential to go backwards as part of this process because of the escalation of the criteria from the directive into the legislation was giving it greater weight, and so therefore whether that was going to be the existing criteria were still subject to abuse by agencies. So what we continue to campaign about, and will be continuing to campaign about in stage two, is whether or not some of the dot points in relation to criteria for temporary employment are appropriate. And looking at those in particular was in relation to, there was a phrase there which was whether the temporary employment could be used whether the funding is uncertain or unknown. And that had been a significant challenge for us in a range of agencies where agent departments were using this as an excuse to continue to employ temporary employment, and then basically saying the budget, everything in the budgetary cycle is uncertain, and so therefore we were having a number of cases determined by the Public Service Appeals Tribunal that were reinforcing the fact that temporary employment was appropriate, it wasn't inappropriate for departments to employ temporaries within these circumstances. So the change to the legislation moved that from uncertain to being unlikely, but we've also got commitments from government to say that this will be something that will be reviewed over the first 12 months of the operation of the Act, to come back in stage two and have a further conversation about whether or not this legislation actually delivers a change of employment within the public sector to provide a higher level of permanency within the public sector. I certainly think that the change is potentially significant from uncertain to unlikely. I think it does change the nature of that, but it is going to be really a matter of the lived experience over the next 12 months as to how much departments are actually interpreting that or are trying to use that as a loophole. And then also, as we move from the Public Service Tribunal to the Industrial Relations Commission, it'll be the same people hearing the appeals in relation to temporary conversions, but that the the fact that it'll be in the Industrial Relations Commission will mean that those decisions are then binding on each other. There'll be precedent value, and there'll be some appeal rights to the Industrial Court and the full bench of the Industrial Commission and then the Industrial Court, rather than currently the only options we have in relation to appeals are to the Supreme Court. And we have been successful in those Supreme Court appeals, particularly in a couple of the key decisions around temporary employment. But we would want to be able to have clearer binding precedent coming out of the Industrial Relations Commission. So this one we think is an improvement, or we certainly think is an improvement. Whether it actually has a substantial change in behaviour of agencies, we'll have to wait and see. Then in terms of the other changes to the conversion, so that was about the employment process. Then the temporary conversion process, the original amendments required that the same criteria be used in terms of whether or not someone should be converted from temporary to permanent. Some of the criteria that were in the original part, the earlier part of the Act, or being introduced in the earlier part of the Act, in terms of when temporary should be engaged, was reflected in the conversion process. So we were able to successfully prosecute the argument that was potentially going to be able to make it harder to win conversion processes. So those criteria were removed in terms of that process, and then we will be able to. Then there's a key phrase that still remains that we can live with for the first 12 months. We want to see what it looks like in relation to the longer operation of the Act, and that is that there has to be the genuine operational requirements of the agency. That is, we think that there is some good law, precedent law around this already, not in relation to temporary employment, but more broadly in an industrial sphere. But we'll have to wait and see in terms of the way that agencies deal with it, but more importantly, how the appeals mechanism is dealt with by the Industrial Relations Commission. We are expecting conversions to become harder at the moment, given the pressure agencies are under over the savings and debt plan. So we're not expecting agencies to become good employers overnight because of the legislation, but we are hoping that successful prosecution of appeals through the Industrial Relations Commission around the terminology of genuine operational requirements, we'll start to see some established case law that will be published by the QIR, the Industrial Relations Commission, in a way that the public service tribunals decisions, same people, different act, haven't been published. So therefore, there hasn't been that level of clarity, and there hasn't been that level of precedent. But we think that the genuine operational requirements should be a step forward in terms of how those appeals are dealt with. If it isn't the case, we will then look at going back in phase 2 and re-prosecuting the argument about exactly that definition. And as part of this process, we will also be looking at how the data is going to be provided. We're looking at the agency level to try and get clarification and reporting at the agency consultative committees about what decisions are being made, and then also being able to track through the Industrial Relations Commission what appeals are being made through that process. There was also significant debate around the question about the merit principle versus in terms of the Act, and what requirements there are in relation to this. That there were some amendments about that were being argued in terms of this, but the merit principle refers both to the process selection, but also the fact about whether the person's performance in the job, and that is retained within the conversion process, which is important in one of the other changes that I'll talk about in a second. But also then secondly, the other major change that we were able to successfully prosecute was a challenge around the conversion for casuals in particular, but also temporaries who are less than full-time, that agencies were seeking to say, if you're working 4 days a week as a temporary or 4 days a week as a casual, we're willing to convert you to 1 day a week permanent, take it or leave it. And that would then mean that there is the people were being forced to either drop their hours to achieve permanency, or if they wanted to maintain their income, they would have to knock back the offer of permanency. So what we've been able to achieve through the late amendments to the legislation is to provide a appeals framework about the FTE component of which people are converted. So therefore, if a non-full-time person is made an offer of conversion at a set of hours that is less than what their standard hours have been over the last couple of years, they can appeal, they can accept the conversion and then appeal the decision as to whether it's kind of 2 days a week or 4 days a week, or kind of 25 hours or 30 hours rather than 36 and a quarter. So that has been, particularly in the schools environment, a significant issue, and in the health environment. In terms of the other public service departments, most of the conversions we're talking about are full-time, so we'll have less impact there, but certainly it has been an issue that we're hoping, we know that the current changes will make a significant process to do that. So then in terms of the other major changes and improvements we have had in terms of the higher duties, was that we have been prosecuting the argument that we had significant improvements for long-term temporary workers over a period of time. And what that had meant, there have been effectively two classes of workers: that long-term permanent workers who have been acting up potentially 3 or 4 classifications, had very few rights compared to someone who's sitting next to them who didn't have permanency, could get converted across to a permanent position. So if you had an AO5, 2 AO5 next to each other, one temporary could get converted to a permanent AO5. You might have an AO2 who had been 3 or 4 years acting as an AO5 because of organisational change or whatever. They had no rights previously in relation to the ability to get certainty of income compared to certainty of employment. So the original amendments to the Act didn't go very far in this regard. They really were just reflecting the status quo in terms of the recruitment and selection process that had always been there but never used by the employer. So what we have been able to achieve during this process is that the rights of long-term higher duties people are reflective of the same rights as long-term temporary people. In terms of that process, the criteria for assessment, first of all, the biggest issue with this is that there is now appeal rights. So previously on the initial amendments to the Act, there was going to be the ability for the employer to convert, but no appeal rights. What we know is when the employer has these rights, which are in the worker's favour, they never actually implement them unless they're forced to by an external agency through an appeals mechanism. So we now have appeal rights in this regard. Then the decision that is made by the employer in relation to whether to convert long-term higher duties or not is now going to be on the same criteria as the criteria for temporary to permanent conversion. So the term genuine operational requirements is reflected in the higher duties component as it is in the temporary conversion component, as is the regard to the merit principle. And this is significant in terms of higher duties. It's both a risk and an opportunity in this regard, because we have a significant component of our membership who have, in the number of agencies such as shared services and a range of those areas, where long-term higher duties, because of a lack of organisational structure, people have been working in the job for 4 or 5 or 6 years. The whole workforce is on, large parts of the workforce are in these higher duties processes. They've never got certainty of organisational structure, so they've never been able to apply for these jobs. And particularly in the current budgetary scenario, we're seeing a number of agencies reviewing so-called higher duties, and people are at risk of losing 20, 30% of their salary overnight. And so this will now mean that these people are able to appeal the ability to be made permanent. The original directive and legislative amendments would have meant that they had to have gone through a merit process to be appointed. What we know is that large parts of the sector haven't gone through that because of the organisational change process. And so this is about the merit principle rather than the merit processes. And that means we're able to show that the person has been doing the job for a number of years satisfactorily. That should achieve the merit principle as opposed to the definition of merit process, which is a different component of the Act. There are risks around this that sometimes people are tapped on the shoulder. And there's that level of nepotism in this process, and certainly during the first 12 months of the operation, what we're having to make sure is that the appointment processes for higher duties is significantly strengthened and appropriate through the recruitment selection processes to make sure that we stop that level of nepotism and tapping on the shoulder, but at the same time making sure that in terms of protecting the long-term people who are being in higher duties because of organisational change processes rather than just because they know someone, making sure they can get that certainty of income moving forward, particularly in a tight economic environment. And agencies are doing that review at the moment. So there is going to be some balancing around this, and we do need to make sure that moving forward this doesn't open up a Pandora's box in relation to people being tapped on the shoulder, given long-term higher duties and then converted as a way of actually doing selection processes. I think that the ability to protect those people who have got income insecurity at the moment is a key task, and we've prioritised that. But I do recognise that there are some challenges around what that higher duty stuff looks like in terms of the initial process, even before we start to move towards that. But I think also, I think certainly in phase 2, I think also the government recognise, the JAC, it's recognised that the notion of long-term secondments versus higher duty allowance versus a range of other things really needs to be unpacked in the Act and come up with a greater clarity about what is a secondment to another agency versus what is just acting up within your own agency, and that what is, so it's kind of removing that lack of transparency about what is a real job versus what is a short-term relieving in someone else's job, and that's going to be a large part of part 2. So in terms of that, we are going to be working, I probably haven't spoken fast enough today, so I'll try and work through some of this. We can probably go about 5 minutes over time. What we are looking at then in terms of this process is working through as the new directives will be issued. I think the Act was assented to on Monday from memory. So some of these things will start to come into play. And we will then be looking at how whether the conversion decisions are being made by the employer in a changed way as a result of the new Act. We aren't going to be particularly prosecuting the 12-month reviews because we think they're less helpful in terms of the ability to succeed. And we think we're better off winning it 2 years rather than losing it one year and then potentially losing it a second year. And then also engaging at the agency level about working with members, and you'll see some stuff coming out over the next week or so on an agency basis, looking at what we're doing about identifying where there are long-term higher duties, making sure that those people are achieving the merit principle, but then working out how do we then seek conversions, and also from a tactical point of view, both in terms of new appeals to the Industrial Relations Commission versus for both temporary conversions and higher duties, trying to make sure that we have some good cases to develop up good case law in terms of that process. And I think that's really going to be important in terms of changing the pattern of behaviour. We've got some good Supreme Court decisions that we can rely on. We've got some other good industrial commission decisions that's in other industrial tribunals to rely on, but converting that into substantial case law moving forward will be both a strategic opportunity for us and trying to work that through in terms of those decisions that we take, those decisions we appeal, and making sure that we prioritise some key ones that will provide us with the best case law moving forward. And there's also a discussion to be had outside of the public service about what are these through the public service regulations, how much this applies to groups like TAFE and WorkCover and some of the statutory authorities who are currently capable of being roped into the Public Service Act but aren't public servants by themselves. And as we learn from those appeal processes and the lived experience of changed behaviour in terms of employment security and income security, looking at what that looks like in terms of a revised claim around stage 2 in 2021, clearly that'll have to be after the state election, and then thinking through what that looks like in terms of the other processes. So if people do have questions, if you can put them in the chat box, we'll try and get to them as we go today. If not, we'll follow up with you afterwards. And then in terms of the other parts of what we wanted to cover off today, clearly in terms of the state budget, the savings and debt plan continues to be a significant issue in relation to recruitment and selection and loss of jobs within the sector. With that, we have written to every agency. The level of consultation we're getting back about that is less than helpful. But we also have, as part of that process, we did identify that some agencies are telling us that they are going to be reviewing the higher duties processes, and we'll be pursuing that to make sure that they're not taking action against higher duties to avoid the new legislative rights that workers have. But we are continuing to engage with the central agencies and with government and CBRC generally to try and get that question resolved around, particularly for non-frontline, to make sure that the current interpretation that any non-frontline position, if it's going to be filled, has to be filled by a CBRC decision, because clearly that's is untenable in the medium term and the short term, but also during caretaker, there will be a whole month when everything becomes completely untenable because CBRC can't meet because of the caretaker provisions, So we would hope to have some discussions around that and something to tell you over in the near future, and that we are continuing to try and escalate that decision and those discussions as quickly as possible, because if there is going to be a revisiting of the implementation of the original savings and debt plan, or making sure the wording of it is correct, that those decisions are made prior to the state government moving into caretaker on October. But also we want to make sure that the conversion rights in relation to that process is dealt with as quickly as possible. And then the other issue that we are looking at doing is engaging with government agencies in relation to the kind of return to office environment. In terms of that process, there is the ability for the kind of requirement. There was a 25% rule, then moving up to 50% return. In terms of that, there are a number of agencies that are looking at trying to escalate to 50%. We are trying to get back and engage with the Public Service Commission and government generally, but given the recent outbreaks in relation to COVID, that the processes of return to office shouldn't be escalated too quickly, because in terms of the ability to deal with the health environment, we need to be doing everything we can to minimise the risks, and in terms of that minimisation of risks, that process has to be dealt with in another process. And the other thing we were going to deal with today, but we will deal with it at the next one of these briefings, is to talk about also how, as a union, we start to deal with the process that the ability to change the concept around what is a public servant in a broader sense, and given the nature of what the Courier Mail's been doing, and Together has a campaign that will be which will launch this week in regional Queensland, and we're dealing with across the state, that there is the ability to try and get a better understanding of the value of the work of public servants, and trying to have an understanding that public servants aren't just people who work in 1 William Street, that public servants provide significant and important services to the community as part of that process. So from that aspect, that's where we will be going to next, and that'll be till we're going. So in terms of that, that's as probably as we've already gone past the half hour in that. I know we had a number of questions on chat, and we'll try and get those answers back to people, and we'll cover that also in the email follow that will come out from this, but also for those members and delegates who are seeking opportunity to engage in more detail rather than just having to listen to me, which these teleconferences have become a bit like. We will be doing something at the agency level as well, where there's sufficient interest to start working through how do we develop a process and strategy at the agency level through your agency consultative committee to engage and force real outcomes in terms of your lived experience, in terms of getting better employment security and better income security. But I do also want to take, just before we sign off, an opportunity to thank everybody who's been involved in the campaign. What you did in terms of signing those petitions, getting that pressure on your local MPs was significant. We were able to get a number of significant improvements in terms of the legislation because of the work that you did. And while we were able to make the submissions to committee, it was real public servants talking to local politicians about the importance of your work that delivered the fact that we're able to get those amendments that will hopefully make real and significant change to you. So thanks for everybody who got involved. You did make a significant difference, and also hopefully we'll be able to engage at an agency level with working with delegates and organisers in each agency to make sure that we can convert the important wins we've had through this legislation into practical and real changes to you prior to caretaker, during caretaker, but also placing us in the strongest possible position moving forward to whatever happens after the election, whether it's a change of government or re-election of this government. We are going to be facing some significant challenges given the nature of the budgetary situation for state government, and we need to be in as strong as possible to move that. So thanks everybody for your time today. I'm sorry we were a bit rushed, but we had a bit to get through, and we will try and address all the questions on the chat through an email that'll come out probably first thing tomorrow morning, and that will also give you all an opportunity to directly respond to that email, and we'll get someone to contact you as soon as possible. So thanks very much for your time. I'm sorry we've had to cancel a couple of these in the past, and we will be certainly doing a follow-up of these in the next week or so to talk about the nature of the Together campaign, but also to talk about where to next in terms of the the way that we can really improve employment security in the public sector as well as income security. So thanks everybody, and we'll talk soon.